Um, Faculty of Law. I was tempted to say this Faculty of Law and Sport. But I don't think I have gotten instructions and advice from my learned IP counsel, Dr. Crowe, to use Dr. Mansing's trademark. Welcome to the first of the Mona Law series for this semester. As you know, this room is familiar to many of us. It is a place where we endeavor to engage the legal profession in all aspects of law that and I see one of my classmates taking her seat over there. We're classmates, although she looks as if she just graduated. But I didn't age as gracefully as she did. But I'm letting the cat out of the bag, Donna. In those days, we didn't have this wide range of opportunities to explore all these areas, and we were confined to Mr. Bland, Tony Bland's trust and real property, and these other mundane, but for those who practice, quite profitable courses in law. But welcome. Dr. Amir Crowe has been with the Mona Law faculty for just a year, and in just 1 year, he has done so much to spread the name and the reputation of Mona Law and what we do here, that we know not only read books, but we also go into the fray and we win cases. And that Dr. Crowe has done. He came to us from the University of Windsor, where he quickly rose to the level of associate professor, and his area of specialty or areas of specialty is in the IP, technology law, and as well as sports law and sports arbitration. And I should say, anywhere that there is a challenge to rights, there is Dr. Crowe to help. He has represented athletes in over 50 matters to date in national and international arbitration proceedings. And I don't think that there's anyone in this region any lawyer who can make that boast. He's certainly, and I can say it, he may not, but I can say it, the preeminent sports lawyer and sports arbitration lawyer. And that is the direction in which we would like to see the law faculty, and I'm on the review committee of regional legal education for the Council of Legal Education. And increasingly, we have to forget the idea that there's anything called theoretical law. Law is practical. How do you make the law work for people? And he has appeared numerous times before the Swiss-based Court of Arbitration for Sport. And just last month, and I remember that he himself, an average squash player, overdid himself a bit and got a little injured, and although suddenly he became well when he was presented with a very difficult matter, and that involved the Canada's Olympic selections in regard to its speed skating long track team. As you know, the Winter Olympics just ended in Korea. And he was successful in having the selections reconsidered. He is currently involved in a Commonwealth Games dispute concerning the non-selection of 2 international level athletes to Trinidad and Tobago's table tennis team, the merits of which are being heard in the Trinidad and Tobago High Court of Justice next week. The Olympic reconsideration and the hearing of a team selection dispute in Trinidad's High Court are 2 precedent-setting matters, rarely, if ever, seen in the sporting jurisprudence. And this, again, is the direction in which I want to see the law faculty and the academic members of the law faculty cross over into the area of making precedent-setting cases for the law. And I hear that I was told that at the law school they study a case that I did called Wear and Tree on the Property Rights of Spouses Act that sort of set a precedent and so on. And somehow when you're in these closed confines, you don't get to realize what you have done. But certainly the Mona Law series is an occasion for doing so. So I am not going to prolong this too much. We are going to have a couple other series. Right now, we have an LLM in sport law being developed, and we hope to roll it out in September in the new academic year. And this is in collaboration with the Faculty of Sport. And it will not only be a master's in law, but also we'll be doing certificate and diplomas as well as professional training in areas of arbitration. And this is right across the Caribbean, because the Faculty of Sport is what we call a university faculty, in that it is across all 3 campuses. And we are working with the Faculty of Sport to roll out this new professional degree program for in terms of sport arbitration. I welcome Dean Mansing, who is the Dean of the Faculty of Sport, and he has joined Dr. Malcolm, sorry, not Dr. Malcolm, Dr. Crowe on the podium to do this Mona Law series today. So I welcome you and thank you very much. And I see yet another one of my classmates. I am very happy to see my classmates here to support Mona Law. And without further ado, I welcome Dr. Amir Crowe.
All right, thank you very much, Dean Jackson. Now I know what my eulogy will sound like, so I appreciate that. So I just, before I start, I did want to build on what Dean Jackson said. We at the faculty have offered a course on sports law since last year. And I can tell you that last term we ran the course, and as part of the course, the students do a mock arbitration before the Court of Arbitration for Sport. And I will say that for students who've never arbitrated, the level of advocacy was phenomenal. It was amazing that what students can in fact accomplish when we add some experiential components to the curriculum. So I leave that there. My talk today is about how do we design an effective sports dispute resolution system in the Caribbean. And it is a Caribbean-focused talk because, as the Dean said, I have done cases throughout the Caribbean and even Olympic cases involving Caribbean athletes. And there is a massive paucity, there is a massive lack of dispute resolution systems for athletes. And today I'm not talking about doping resolution systems because that system is well set out in the World Anti-Doping Code, and that system is fairly mandatory for anyone that even wants to compete in any sort of amateur or Olympic level sport. So today, the dispute resolution systems I am speaking about relate to team selection, funding, carding issues, and discipline issues. And for anyone who came in, what I did was I put together a sample appeal policy that can in fact be used across any sport, across any discipline. It was based on a much longer dispute resolution policy. One was 22 pages, one was 14 pages. I mean, I don't think any athlete is going to read a 14-page document. So I made it 3 pages. I tried to make it 2. It wasn't possible. But I will talk more about the sample appeal policy, but it is there and it is designed to be applied across any sport, any discipline throughout the Caribbean. Right, so I want to start out with some of the existing problems in the way sports disputes are in fact handled. One of the big problems with the way sports disputes are handled today is we still haven't recognized that sports law, it's not like criminal law, or it's not like civil litigation, or it's not even like some hybrid of the two. It's a completely different animal. And part of it too is lawyers are trained to either be civil litigators or criminal litigators or family lawyers. That's kind of the big 3 categories. But there has to be a recognition that sports law is truly a unique system of law unto itself. One of the big things I noticed is like when it comes to even doping charges, that's how they're framed. Disciplinary charges, that's how they're put towards athletes. They're not charges. No sporting body has the ability to make a charge against someone. They're allegations, right? Even the language is still very much entrenched in a criminal law frame of mind. And the speed and timelines. Again, sports law, we do not speak of a case going beyond a year. A year to us is like our Pratt and Morgan. Like honestly, a year to us is a decade in sports law. Sports cases are decided in days or weeks. Maybe you get a case that goes 6 months, Court of Arbitration for Sport. Those cases seem to be taking a little longer than usual. But sports cases are decided in days or weeks. And for any lawyer that's trained traditionally in litigation, the idea that a client can retain me today and we have the mediation tomorrow and we have the arbitration on Friday, they scream for the ceiling. They have no idea how it's possible, how, oh my God, natural justice is breached, how am I going to prepare, how am I going to do research? But that is the world of sports law, right? And 2 weeks ago, I had an arbitration where an athlete who was affected by it participated with a counsel, and that was exactly his reaction to it. He was a Montreal-based lawyer, And he didn't understand how we could possibly be having this call on Monday with submissions due Wednesday, with the arbitration Friday, with the decision due Sunday by 12 noon. He couldn't possibly understand. He started screaming and so on. And then the arbitrator flatly said, this is how it is in sports law. The executive director from the arbitration center, she interjected, which she never does. She says, 5 days is a lot of time for us. There have been arbitrations where it's literally been conducted in the airport as you're about to board a plane, and the decision was rendered within the hour. Like that is how sports arbitration works. And again, to people who are traditionally civil litigators, criminal litigators, it's mind-boggling that as lawyers, you're probably saying, how is that process even fair? How do you get the evidence out? How do you... In any case you do, even if it took 10 years to do it, there will still be some lack of evidence. There will be still some... Every case is rough justice, whether people want to admit it or not. Sports law just recognizes that an athlete's shelf life, and I don't like to say that, but an athlete's time as an athlete is very limited. It's less than a decade. Maybe from like 18 to 28, right? And so every month that's lost in a dispute is equivalent to like a year to that athlete. Because anytime you have a disciplinary charge over an athlete, you have a team selection issue, you can't compete at some sort of world event or something, that has implications for how you qualify for other events, right? So if you can't go to Worlds now, then you don't have enough points to get to the Commonwealth Games, or you don't have enough points to get to the Olympics. And so all of those things have bearings, and they do require very, very, very quick resolution. Right? And another one of the problems is, even when tribunals are constituted to deal with sporting disputes, no one really knows what the rules are. Right? So the lawyers who come into the room, they either start thinking of it from a civil procedure point of view or from a criminal law point of view, when in fact, again, it's neither. Right? And when you do a case with the Court of Arbitration for Sport, it's based in Lausanne, Switzerland. Believe it or not, there are no rules. Imagine a system of law, mind-boggling. So there are no rules set out by CAS as to how each procedure goes. Each panel decides on its own rules. There are rules for timelines and submitting the statement of appeal and appeal brief and so on, but the actual rules of the hearing are things set out by each tribunal. Each panel sets its own rules, because that is something in arbitration. Each panel has its own power to set its own timelines and deadlines and so on. So when these cases are heard and there's this reference to rules of civil procedure and so on, again, it doesn't recognize that sports law is its own unique animal. And another problem in the Caribbean that I have personally experienced to the detriment of great, great athletes is there is, in fact, this tendency to ignore a dispute. So you raise a dispute, and then people just ignore the email, and then I'll ignore the email because the flight leaves Friday morning. So by the time I ignore the email, the athletes we selected, they're already on a plane, so this athlete who thinks he or she should have made the team, too bad, because the appeal is now moot, everyone's on a plane. Right? And I will use a real example in Trinidad. It was a case, Timo Williams, the gymnast. She was one of Trinidad's great hopes for a medal in the Rio Olympics. And at the qualifying event before the Olympics, she was removed on the Saturday before the Sunday morning she was competing. She was removed the Saturday, right? And I remember I was in Florida and I got the phone call. I literally stopped at a gas station and I drafted the notice of appeal and I filed it and I copied the Minister of Sport. I copied everybody in Trinidad that had an email address was copied. And everyone ignored because nobody could understand. And I set out a timetable. I said, we can exchange submissions by midnight. We can have the arbitration 9 a.m. till 11 a.m. A decision can be rendered by 12 noon because she has to compete after that. just ignore it. And then by Sunday, it's too late. The other athlete she was replaced with had already taken her place, and then the whole matter is moot, right? And again, it seems weird that you can resolve an entire dispute in a day, but even Olympic disputes, in fact, there is a rule in the Olympic. When CAS goes to the Olympics, a decision has to be rendered within 24 hours. That's the actual rule. So if you stay up all night, you stay up all night. That's just your job as a sports lawyer, right? So this has happened more often than not. I also represented Jason Morgan, Jamaican discus thrower, for when he felt that he was unfairly left off of Jamaica's team. Again, we raised the dispute. Exactly. That sound you heard of nothingness, that's the sound I heard. And then the team selection was already made, and then the team went off to compete, and the dispute again was ignored. So there is that lack of a framework, because in the absence of a dispute resolution policy, athletes don't have anything they can point to and say, look, you have to constitute a panel because as part of your funding agreement or as part of your agreement with the ministry, you said I am going to deal with disputes this way. And in the absence of that, athletes have no recourse to any sort of meaningful dispute resolution process. And a last problem is anyone, if you follow the current Olympics, Court of Arbitration for Sport has been mentioned numerous times. So they are a private arbitral body, despite the grandiose name they've given themselves. They are a private arbitral body, and they are in charge exclusively of Olympic disputes. So the Olympic Charter gives them the exclusive right to deal with any Olympic dispute. And when it comes to doping matters, there's generally an ultimate right of appeal to the Court of Arbitration for Sport for doping matters. And team selection matters and disciplinary matters, because of the ultimate right of appeal for doping matters, many sports bodies also give the Court of Arbitration for Sport as being the ultimate right of appeal for disputes involving those matters. But I am not a fan of the Court of Arbitration for Sport, not because I've lost there, but I'm not a fan because the costs to go to CAS are prohibitive. The filing fee for CAS alone is 1,000 Swiss francs. That's just the filing fee, the stamp duty as whatever, right? 1,000 Swiss francs. So unless an amateur athlete in the Caribbean has 1,000 Swiss francs lying around just to lodge the appeal, and then if you have a single arbitrator, the cost is between 8,000 to 12,000 Swiss francs. So your total cost for a single arbitrator at CAS is between 9,000 and 13,000 Swiss francs. So no athlete in the Caribbean really has a meaningful recourse to CAS. So sporting organizations could put it in their policy all they want. You have an appeal. If you don't like our decision, appeal to CAS. There is no meaningful recourse to CAS, right? CAS does have a legal aid system in place, but again, you have to apply for that and be approved for it and so on. And as long as you're middle class and upwards, you will be denied, because I've had athletes who were denied. Another issue with CAS, and it's the old CCJ versus Privy Council debate. I mean, CAS, it's Lausanne, Switzerland. It's primarily white arbitrators from North America and Europe. And there is this concern, a genuine concern, that there is no appreciation of local culture that may in fact impact the appeal. I had a CAS appeal where my client ate horse meat. So he went by his sister Sunday lunch, had rice, dal, so split peas, and what looked to be beef. So he sat down and ate a whole bowl of it. And it turned out, and then she's like, oh, you know that's horse meat. And then when I tried to explain it to CAS, that when you go, like Sunday lunch in the Caribbean, you don't sit down and be like, oh, is this on WADA's approved list? Is this horse meat? Is this meat acceptable? No, you eat lunch. You don't want to, you have lunch at your family's house. But the CAS, they said, no, as an athlete, you have to ask, what's in this rice? What's in this dal? What's in this curry? But I'm trying to explain that to a panel of white arbitrators is a much difficult task than it seems, right? To try to explain that when you go by your sister for Sunday lunch, you're not really asking what's in the spinach or what's in the, right? So a little later on, I do have a proposal for how we solve the CAS issue, but I do have serious concerns about the Court of Arbitration for Sport. And to give you an idea, in CAS's rules, is Rule 59, once a dispute is referred to a panel, a decision has to be rendered within 3 months. So even by CAS's own rules, their decisions tend to be 3 months. It should be 3 months, right? But then CAS has the power to extend their own time limits because it's arbitration, so they can do that. But these are generally the problems that I have experienced, and this is, and I really am speaking about just the Caribbean disputes I've dealt with, right? These are the problems I have encountered, and really the solution, the big solution is sporting organizations need to adopt specific dispute resolution policies. So anyone who came in here today, you should have a 3-page policy that I put together over the past week, and it should contain the basic elements of what you need whenever a dispute arises. And so a team selection dispute, right? So normally all of these sport organizations, you have a committee that would meet, they decide who's on the team that goes to Worlds, right? Necessarily, you leave athletes off that list, and there may be athletes who feel, well, look, I should make this team, and in the absence of any dispute resolution policy, there is no meaningful recourse, except going to the High Court, which is what we've had to do in Trinidad. And even the High Court is saying, we really aren't the best place. Like, we're not accustomed to handling these appeals in a matter of weeks and months, you know. We're not really. So we have an injunction in place right now, and the reality is, if by next week it's not solved, then Trinidad sends no one to the Commonwealth Games for table tennis. And apparently the Federation is fine with that too. It's wisdom of Solomon all over again. So you really don't want the courts to be seized of the matter, and not because that they lack any sort of ability to deal with it, but sports arbitration is its own unique animal, and it is designed to resolve disputes very, very, very quickly, right? And disciplinary matters are another thing that you need a written dispute resolution policy. All too often, I have seen athletes receive letters. They said, oh, the board has met, and the board said you were out till 2 a.m. and you came home cussing and drunk, and so you are banned from the team for 2 weeks. Have a nice day. Please be governed accordingly. But there's no mention, no ability to appeal that, to question that, to anything, and that is fundamentally wrong. If you are unilaterally imposing discipline on an athlete and they have no right to appeal it or question it impartially, then it's fundamentally wrong. And disciplinary matters need to be dealt with under these dispute resolution policies that absolutely need to be adopted, right? And fundamentally, in any dispute resolution policy worldwide, so when these policies are developed throughout the world, the underlying principles are a respect for natural justice. And it's because throughout the world, civil law systems, common law systems, Islamic systems, and so on, two principles have emerged that irrespective of where your jurisdiction is, you have to respect these two principles to, in fact, have a fair hearing process. And these principles may, in fact, be familiar to lawyers, but I will make it very relevant to sports disputes in particular, because each one of these elements, I have been involved in cases as recently as this year where they've all been violated, right? So the fundamental first principle of natural justice, first principle, is you have a right to be heard. So if there is in fact something put against you, you have the right to be heard in response to it. A unilateral letter of discipline that with no right of appeal, no right to question, fundamentally breaches rules of natural justice. It's fundamentally abhorrent, right? And sort of flowing from that is you generally have a right to know the facts against you. And in 2016, I was involved in a case, Nikisha Blake against Trinidad and Tobago Badminton Association, TTBA. And they said, these are the charges against you again. 11 charges were listed. And it's Friday afternoon, 5, 6 p.m. Your hearing, by the way, is tomorrow morning. Have a nice evening. Literally. So these are the 11 charges against you. We're not telling you who gave what evidence. We're not presenting you with anything. It's about 5, 6 o'clock Trinidad time. Your hearing is tomorrow morning in Sangre Grande. See you then. That is not a fair dispute resolution system, right? If there are, in fact, allegations against you, you have a right to know the facts behind those allegations. You have the right to sufficient time to prepare a defense. To give anyone, and let alone an athlete, hours to prepare a defense on the bare allegations, nobody could defend against that. No lawyer could even defend against that if you don't know what the evidence is against you, right? So, right to be heard is essential. Time, date, location of the hearing seems self-evident. Last summer, I had an Ontario Games dispute. Ontario Games, you think they would get it right? They said the games were ending in 2 days, so we didn't really have time to notify the athletes, but we held a hearing in your absence, and we disciplined you, and the result is you're banned. You have to send us a notice of apology and return your Ontario Games clothing. And so all of them accepted it, except, thank God, one didn't. And she told her coach, and her coach phoned me, and I got on the phone, and I just had at them. And the funny thing is, for the appeal, the person who sat as the chair of the panel who issued the discipline wanted to be the representative for the appeal. It was so bizarre, and I'm telling the arbitrator, I'm like, this is like a high court judge now sitting as counsel before the Court of Appeal. It makes no sense. And they realized they screwed up royally, and we got the entire discipline retracted. I said, if this goes to arbitration in Ontario in 2017, you'll be humiliated. So everything was retracted. So she won, but the other athletes, they sent in their letters of apology and so on. So if you think that this is self-evident, even last year it happened that people were not notified of a hearing. Right? Complete disclosure, again, seems self-evident. It's not. When you're dealing with disciplinary disputes, team selection matters. There should, in fact, be minutes of that team selection meeting. Right? When that committee is meeting, high performance committee, whatever they're called, the name changes every year, it seems. When that committee meets, there should be minutes of the meeting as to why people were chosen versus not chosen. Sporting bodies throughout the world hate revealing that. All of a sudden, it's privilege and it's lawyers, and there's no privilege that attaches to meetings of a selection, minutes of a selection. And that disclosure is always resisted. But for a fair hearing, if you are challenging a selection decision, that has to be turned over. And one example is, like I had a client last month, he plays water polo for a Swiss league. And as part of, they kept him off the Canadian national team because they said, well, we have these 3 guys in the Italian league, and the Italian league is much better than the Swiss league. That was it. That was just the sentence. And then so I cross-examined, and I said, on what basis are you saying that? They're like, they literally had no basis. By the way, the committee was 4 of the 5 of them were Italians, by the way, on the committee. I just point that out. 4 of the 5 of them were Italian. One was an Italian Olympian. Right? And they just said, the Swiss league is just not competitive, so he's off. That was literally their rationale. They had no other grounds, because he met every other ground, right? And they resisted turning over those minutes till the 11th hour, and then I kept screaming, if the arbitrator does not compel disclosure, the hearing is unfair, and then we will reappeal this again to CAS because you, in fact, conducted an unfair hearing, and then they had to disclose it. So disclosure is always resisted in these matters, and sporting organizations should be very careful now. If you haven't been minuting how you make selections, you have to, because if you don't, then the athlete has the right, everyone on that committee, to cross-examine every person at that hearing, if you don't put forward those minutes of the meeting. And I'll tell you, I did a case last year. The committee that made the decision, they accidentally turned over emails where they admitted changing the minutes of the meeting after we filed our appeal. They said, it's McGuire and Speed Skating Canada, it's a public decision, thank you. It says this particular rationale we used to not put Lauren on the team may aid Lauren in her appeal, quote unquote. And I drove a Mack truck through because it was an email thread, so they just turned over the email thread. They didn't really read, because we had 3 days to decide. And at the bottom of the thread, and it was a lawyer on the committee, no less, who said, let's change the minutes because it may aid Lauren in her appeal. And so all of these things happen, and these aren't some random stories. They happen more often than not. So as organizations claim to be moving towards transparency and good governance and all that nonsense you hear, one of the elements of good governance is to document things, and document it and PDF it. Because we have uncovered evidence of tampering with minutes of meetings, and it's very, very disturbing. Right? Allowing parties to present evidence, again, seems self-evident, but in sporting disputes, especially when you're dealing with team selection matters, if I'm saying my client should be on a team, I'm implicitly saying somebody should be kicked off the team. And so that person who should be kicked off the team, they have a right to participate as well. And the problem is, I would say literally half of the team selection disputes I do, the federation does not include that affected athlete. They just deal one-on-one with this athlete, but the person who may be kicked off the team isn't even notified of the appeal. And then if we win our arbitration, then they say, oh, sorry, Joe, you're off the team. We won. If you want to raise your own separate appeal, go ahead. And now that athlete now between these two, they hate each other now. They've been trading for a decade, best friends. Right? It happened in a case, they kicked my client off the team, and they said, oh, sorry, Jacqueline LaBerge, the plane leaves in 3 days, we kicked you off the team. We had a secret arbitration, we didn't tell you. Secret. You're off the team. And then we raised an emergency appeal, and one of the grounds we raised was a breach of natural justice. You have to involve the affected athlete in the appeal, and they have to have the right to participate fully, as if they were, in fact, the athlete bringing the appeal initially. Right? So the right to involve affected parties, affected athletes, that right has to be respected. Even if it complicates things, they have that right, because then you're opening yourself up to that decision being overturned immediately as a breach of natural justice, independent of the merits, to be independent, to just immediately be overturned because you failed to involve that athlete in the process. Right? And then the last is the right to be represented by counsel and other representatives. So the way sports law evolved, it used to be that coaches would be the ones who represented athletes at these hearings, right? Because the hearings used to be constituted, because it's arbitration, you constitute these hearings in a private room anywhere. It could be on site at a track meet anywhere. And it used to be the coaches who would just represent the athletes because of the bond they have, and athletes implicitly trust their coach. Like if your coach says run through broken glass barefoot, athletes will do it because your coach told you to do that. I mean, that is the kind of bond I've experienced they have. But over time, sports law as a practice area really didn't evolve until like maybe 20 years ago. And as an academic area, maybe not until 10 years ago, right? But now counsel tend to get involved in these hearings. But because they're arbitration, like I don't have to be admitted to the Swiss bar to appear before the Court of Arbitration for Sport because it's private arbitration. So there is, in fact, no breach of any obligation. So anybody can represent an athlete. And parents sometimes get involved. I have one literally right now with Karate Canada. Parent is involved. I get about 12 emails a day from dad. I say, Dad, you're not my client. Please refrain from sending me emails from from now, for life. Just leave me alone. Right? So all of those fall under this one basic natural justice right to be heard. And the second right is you have a right to receive an impartial decision. And again, that seems self-evident to people in the common law world, but it in fact is something that raises its head time and time again. So the right to reasons is something well established. House of Lords has said that there is in fact a right to receive reasons. 2004, there was a House of Lords case that said that. In the sports jurisprudence, again, if you follow the Olympics, you've heard of a guy named Dick Pound. I mean, he's always speaking about something. He needs to be quiet sometimes. But Dick Pound said in a case, Blaise Dufour on speed skating, he said that jurisprudence from CAS and the Swiss Federal Tribunal has held that a failure to provide reasons may amount to a denial of a fair hearing with respect to the losing party. And I raise that because many decisions, and there have in fact been decisions that have been 3 sentences long. So the appeal panel, whatever the appeal panel is, they say, something very flowery like, we have reviewed and considered all evidence in depth, and we've denied your appeal, full stop. That's literally what we got. And I'm like, well, as a lawyer, how do I intelligibly tell my client we should appeal this rubbish or not? Because you have to tell, if you're denying an appeal, the right to know why your appeal is being denied is also a fundamental right. So the right to get reasons and to get adequate reasons. They're 2 separate rights. And we appealed on that basis alone. Again, it's the Jacqueline LaBerge case. And Arbitrator Mew, who is now Justice Mew, Arbitrator Mew agreed. He said that these reasons were inadequate. He quoted that same case by Dick Pound, where Dick Pound said the reasons were spare to the point of emaciation. Right? That's just flowery language. So that is important, and that happens time and time again in these cases, that in the absence of detailed reasons, again, a selection decision can be overturned simply on that, independent of the merits. Simply on that basis, it gets overturned. Right? So that is a very, very important right. And then flowing from that, there's a right to be free. The panel or the decision maker must be free from bias. Anyone who follows Privy Council cases know Privy Council came out with a case dealing with the Cayman Islands recently and bias in those courts. And an example I will give about that is Speed Skating Canada. I've done every Speed Skating Canada dispute in the past 8 years. So Speed Skating Canada, they had a selection committee meeting. One of the people on the committee, both of his sons were eligible. One son is the best. He is the equivalent of like Usain Bolt in speed skating. So he's on, no matter what. But then the other son, so he's on the conference call for the decision, and he says, I have a conflict. Fair enough. But what does he do? He stays on the call. So you can't badmouth someone's son if you still stay on the call, right? So Speed Skating Canada's position was, no. Good governance requires committee members to declare a conflict. He declared a conflict and just remained on the, he stayed quiet. But if you want to bad talk the man's son and say why he shouldn't be on the team, you will hold back if dad is listening and dad is in fact the chair of the high performance committee and dad's other son is in fact the Usain Bolt equivalent. Maybe you'll hold back. And both sons are sponsored by Procter & Gamble, which own everything in the world besides Monsanto, right? So I literally found like a university research ethics policy that dealt with people who stay on the phone when because there's no case law on people who stay on the phone after you've declared a conflict. The only piece of something I could find was in a research ethics board policy from University of Waterloo or something that says if you declare a conflict and it's a conference call, video conference, you drop off the phone, otherwise the conflict is still very real. An arbitrator, it was the same arbitrator Mew, I keep reappointing him, I wonder why. So arbitrator Mew agreed, and he said, yes, that I can deal with this. He said, I can deal with this quite easily. It was, in fact, a conflict of interest for this particular person to remain on the line even though he declared a conflict. He should have dropped from the call. And then he sent back, it was an Olympic redetermination again. It was the first one ever to succeed in Canada. And he sent it back to be, those determinations to be reconsidered in the absence of that person being in the room, right? So all of these have arisen in sporting disputes quite recently, and they are things that are fundamental to a fair hearing process. And I put it there because anytime you're thinking of instituting a process, you have to be mindful of these elements. And really, there are two, and they apply across any jurisdiction, really. So flowing from that, I have provided people with a draft policy. And the draft policy, things that I have experienced over the years or policies I have come across, I've tried to condense it into one discrete document. I'm happy to talk about the document, maybe for the question and answer period, but it sets out the mechanics of how the process should work. I mean, it's one thing to talk about it in a vacuum and to criticize it, but it's another thing to put your foot forward and propose a policy. So I proposed a policy. One of the big things in the policy is what can be appealed and what can't be appealed, right? So the policy sets out things that are subject to appeal and things that are not. So like in these policies, things like employment matters and so on, outside of the policy, right? Athletes can't really appeal employment matters and so on, right? So, and it sets out the grounds of appeal. The grounds of appeal are usually limited to things called procedural errors. So the committee didn't take into account certain information or took into account irrelevant information, or there was bias, whether real bias or reasonable apprehension of bias, and so on. And then how is the case managed, right? So the more complex organizations, they hire a case manager to manage the process through the timelines. I don't think that's realistic in the Caribbean. I think the case management should fall to the chair of the panel, or if it's one person, to the one arbitrator. And timelines, I've proposed 15 days, and Atlee has 15 days to appeal a decision. 15 days is normally the standard. At CAS, it's 21 days is the rule. So mine is 15 days, take away weekends, so 3 full weeks. And then the hearing mechanics. So how does the actual hearing process unfold? Because all of this is private arbitration, right? It's not a public process. It is private arbitration. So it is, in fact, self-contained. So it is however the panel wants to control the proceedings. And it is up to the panel to rein counsel in, by the way, because counsel, in these disputes, counsel is the most unwieldy party of all. Between the athletes and the counsel, because counsel starts saying, there's no way we can do it, and I need more disclosure, I need more time, I need 5 days to cross-examine. I can't cross-examine in 1 hour. Yeah, if you cross-examine effectively, you can cross-examine in an hour. I've cross-examined people on the phone and made them cry by telecom. I don't know how, I don't know why he was crying. But you don't need a day per witness. Right? So I know criminal law, civil law, a day per witness, an hour per witness. An hour for examination chief, an hour to cross-examine. Rein it in. I mean, it's private. You can, as the chair of the panel, you can rein it in and say, look, we don't need to know, state your name, your address, your occupation, your kids' names, your wives' names, your spouse's name. No, please. Okay, you're the high-performance manager. Were you there on that day? Right. Get to the question. Right? So the panel, in fact, is responsible for controlling its own machinery. And another solution is technology. Half of sports disputes, more than half, are done by teleconference or video conference. Right? It's not that we all fly to Lausanne and we all have a luxury weekend eating cheese and Ricola and whatever. Like, it's done. In fact, the CAS cases I have done, for doping cases, CAS prefers to see people accused of doping the athlete. They like to look them, the panel likes to look them in the eye. So CAS has 3 times flown to Toronto to hold the arbitration, just because it was cheaper for everyone if they flew to Toronto and had the arbitration. But Kaz was in the room, my client was in the room, I was in the room, but the counsel for WADA, one was in Switzerland and one was in Germany, and they took part by video conference. They cross-examined by video conference. They made my client cry through video conferencing. And so they were, these things are facilitated through video conferencing. We've done entire doping hearing entirely using Cisco WebEx, all video conferencing based. And that is how, again, you achieve a quick timeline. When people have to say, oh, can everybody get to Kingston? And the only time I'm free is Sunday. Oh, no, that's my day off. But as opposed to any part of the day is available because you could dial in from anywhere in the world, then availabilities kind of open up, right? Especially when you're dealing with people from multiple time zones and so on. So teleconference actually is how these things are handled. So there's no reason why this sort of fetish we have in the West Indies of meeting in a room and so on to decide. There's no necessary reason for that in the sports law world, right? Because it's true. I mean, even when I used to work in-house, I mean, nobody wanted to negotiate on the phone. They said we had to fly to Port of Spain to negotiate with TSTT. And I'm like, that's just the way where they like to see you in your face and go for a 3-hour lunch and we'll talk and so on. But for sports law, if there's a sports dispute, it can be handled from start to finish by teleconferencing, video conferencing. And we should use it. Right? We have an entire open campus that's premised on that notion. All of us, half of you in this room are on WhatsApp right now. Like, we all use technology. So why not use it for sports law when in fact that is the preferred mechanism? Right? And a big piece that's left out is mediation. Mediation, mediation, mediation. Even in doping. So I will say initially, 8 years ago, I was mediation's worst enemy. I said, there's no way we can mediate. We're right, you're wrong. It's doping. It's either you doped or you didn't dope. And then through the years, you kind of soften that stance and realize that mediation plays a much bigger role than even the arbitration itself. Mediation is the only part of the process where the two athletes still remain friends after. Arbitration, you've destroyed that relationship. So if my guy says, I should be on the team, these two shouldn't, or this one shouldn't, or whatever, whoever's affected, they are 100% no longer friends. But if we get a mediated dispute, they still remain friends. And in all of the dispute resolution talk, there's a lot of talk about arbitration, but the mediation piece is 100% missed. And it's also resisted because lawyers are not trained as mediators. Lawyers are trained to plant your flag in that ground, don't move it no matter what. The earth collapses, you replant your flag in a closer place. Do not mediate at all. Or we'll just go to the mediation as a joke and laugh for a couple hours and bill a couple hours. It is absolutely the wrong approach. We've had some great results in mediation. And quite frankly, the best results we had in mediation is because both counsel, we all knew the arbitrator, and we knew the arbitrator was a complete wild card. The arbitrator, we had no way to predict what the arbitrator would do, so we said the safest thing for our clients is if we independently came up with our own solution, right? Because this, I mean, anyway, I won't even get into that case. So mediation, big part of the solution. In Canada, the way the disputes are handled, any dispute, doping, team selection, carding, discipline, there is a mandatory 3-hour resolution facilitation. And then I was speaking, there was a private conference with just me and the arbitrators, which is dangerous. So I said, why is this, there's resolution facilitation and mediation under the Canadian Dispute Resolution Code. And I said, they're the same thing. And they said, when they designed the code 10 years ago, every lawyer involved hated the idea of mandatory mediation. So what did they do? They literally renamed it to resolution facilitation. And then all the lawyers were like, oh, well, that sounds fantastic. You facilitate a resolution. And it's left in mandatory, non-binding, confidential, everything else, right? And that process, we have to go through it Sometimes we get on the call after about an hour and a half. We ask politely that it come to an end, but the code says we have to schedule 3 hours for resolution facilitation, which is mediation. And I will say, even for doping matters, which I thought mediation completely useless for, doping matters, it does help narrow what the issues are. Because sometimes the doping bodies, CCS or JADCO or whoever, like, they may think the issue is this, we may think the issue is this, there may be this bit of overlap. The resolution facilitation, it allows us to actually agree that the only sticking point is this, right? Like were the samples left unattended during shipping, as opposed to everything else you want to throw in about people showing up, wearing badges, wearing ID, let's cross-examine the entire lab and so on. When in fact, all we questioned was, it said there was a half-an-hour window between when FedEx picked up the thing and when you all said you shipped it. That's our real concern about tampering with the samples. So then we both agree going forward for the arbitration, that's the only issue we go forward with. So even for doping cases, mediation does in fact play a big role. So I mention it again because it seems foreign to sports law, but massive, massive scope for mediation. And there's one thing I want to end on, and it's an idea. So the way all of sports disputes are traditionally handled, the first level of appeal is normally internal to the sporting body. So the sporting body is the one that constitutes the panel and deals with the dispute internally. And generally, there is some right of appeal to some way, right? So normally, it would be to CAS, right? So you'd have to appeal to Switzerland and so on. I think, quite frankly, that there is scope for what I call the Caribbean Sports Tribunal. So a regional appellate body. So after the internal dispute is handled, because what you find is, as an athlete or as athletes' lawyers, you missed, if I have a dispute with the Trinidad and Tobago Table Tennis Association, and they are the ones constituting the panel, I'm immediately distrustful of that process, right? So there always is some external recourse to appeal in every system of sports law. It traditionally goes to CAS. In Canada, it goes to the Sport Dispute Resolution Center of Canada. I think there is scope. There probably isn't scope on an island-per-island basis, but regionally, there could in fact be a regional tribunal that dealt with appeals of decisions, or if in fact the sporting body fails to constitute a tribunal at all, or fails to constitute a tribunal in a reasonable time, you have recourse to this body. And I mean, I don't want to harp on it, but sport, if anything, I mean, CARICOM failed, but if anything has a hope of unifying a region, it is sport. North Korea stopped nuclear testing for the Olympics. They shook their hands with their biggest enemies. They sat next to their biggest enemy, right? So South Korea and the US, they sat next to them. Like, if anything has a chance to unify the Caribbean, it is in fact possibly sport. And a regional sporting tribunal may in fact have the ability to unite us, because sport is the only time people literally put guns down, stop fighting, and actually bond over something, right? So I think there is in fact scope for an appellate tribunal to deal with team selection and discipline, right? Because like I say, the doping, the water code has its own system of appeal to CAS, but for our own internal purposes, I would forego any right to CAS and somehow think of constituting a regional sports tribunal. Maybe all of the Olympic associations in all the islands, they are the ones who could spearhead that, because Olympic disputes, I mean, as an athlete, being denied a chance to the Olympics, I mean, that's like, you know, you write the last chapter of your doctorate and people say, oh, I don't want to examine the doctorate. Like, Olympic disputes, not being on an Olympic team is the biggest crushing blow to any athlete, and to not have a right of appeal to that non-selection, that honestly is the biggest disservice you could do regionally to any of your athletes. So I just put that there as a possible solution. And like I say, I know Dean Mansing will have some comments to make, and I'm happy to discuss the policy, but this isn't supposed to be a lecture, so I won't take you through the policy, but if there are questions in my sample policy that people have, I'm more than happy to address it during the question and answer period. So that's it for the formal part of things. Thank you.
Now I know that we all are very jealous that we are not studying law now so that we can do this exciting area. And in fact, Dr. Crowe introduced this semester entertainment law. So we are really and truly moving ahead in terms of law that really affects us in many different ways. So if you hear anyone say that we are training too many lawyers, tell them to reduce the number of areas where lawyers are involved, because increasingly lawyers are involved in every aspect of life, and we intend to continue that trend. Now, the other profession that's always seem to get involved in our area of life are the doctors. And this is why the lawyers and the doctors are regarded as the noble profession. These days, the priests and so on are getting a lot of flack, so, you know, we're not going to go there. But we have Dean Mansing, who is an orthopedic consultant orthopedic surgeon, and who has been practicing sports medicine for many years. And we are delighted to have the collaboration with the Faculty of Law. And this is where the university is also moving into collaboration in between disciplines. In fact, what I am now negotiating in terms of our strategic planning is double degrees, where you would come to university and you just don't walk out with a law degree, but you will walk out with a degree in two disciplines. You will recall that in Cave Hill, you could do a double major in law and sociology or law and economics, but then you're half a lawyer, half a economist, and that's not what we want. We want persons who are experts in both areas so that they can carve out the new ways in which they can infiltrate into your into the lives of everyday citizens. So I am going to ask Dean Mansing to offer his comments regarding the presentation we just had by Dr. Crowe.
Thank you very much, Dean Jackson. And I will admit that it's a very unsettling experience for a doctor to speak before lawyers. It's usually not under very pleasant circumstances. And I was wondering why it is that I was going to be speaking at a Mona Law series. But when I came here and saw that there are actually people in the sports fraternity, apart from lawyers, Mrs. Blackwood, Dalton Myers, etc., I think I'm a bit more at ease. But if you do have the answer for why I'm standing here and giving comments, please let me know, because I don't. However, the way that it was put by Dr. Crowe, the entire presentation actually was a major eye-opener. I feel that this is something that we need to expose to a lot more people involved in sport. My own involvement was that when I got involved in sports medicine, so to speak, I actually went and did it as a specialty out of Australia, simply because I figured that if you're going to get involved with it, you've got to get educated in it. And while doing the program in Australia, I realized that this is something that we owe the athletes of the region, not something we offer them. This is something we owe them. And so we started our own sports medicine programs at the University of the West Indies about 12 years ago. Following from that was the opening of the sports medicine clinic, where we're offering specialty treatment to athletes from people trained in sports medicine. And I'm saying this because in the opening remarks by Dean Jackson, he mentioned that law is practical. And the sort of collaboration that the Faculty of Sport and the Faculty of Law are going to have, hopefully will not just be academic, but perhaps would go on to see, just like the Sports Medicine Clinic at University of the West Indies, sports law clinics. Or maybe, through the Faculty of Sport and Law, the Caribbean Arbitration Center could be set up. But I think there are a lot of practical aspects that UWI can offer through collaborative work between faculties like law and sport. However, as far as the presentation is concerned, it was really an eye-opener because the speed at which you do things, even for a surgeon, was pretty impressive. The obvious question is, why doesn't that apply to other aspects of law in our region? You know, the second question is that, is it always necessary to make the athlete cry in arbitration? But seriously speaking, my concern is, and this is something that, you know, I'll ask Dr. Crowe to respond to, that in a culture where we're not used to expediency, in a culture where we're not used to perhaps working on weekends to open and close cases and so on, how do we instill that culture, or does it exist already in the region? Because what you said are very pertinent things, that sometimes you have a day or two to get before the plane leaves. I know for a fact that there are many major sporting bodies that do not keep minutes of selection panel meetings, etc. And I think opening the eyes to athletes, if nothing else, to their rights, has been probably the hallmark of this presentation to non-lawyers. And to that extent, I'm very, very appreciative. The other thing that I found very, very useful was this 3-page document, which is a draft for a sample appeal policy, which I understand in Canada ranges from a 16-page document to an 11-page document that nobody can understand. I myself went through this and could understand what was going on. And I think that it's, you know, templates like this which are very useful for the common man and the common athlete to avail the services of counsel and to understand what's going on. So I congratulate the Faculty of Law for the series, the Mona Law series, but this actually had much broader appeal, and I would suggest that we actually look through the various Olympic organizations, I know the president of GOA is here, to try and spread the word further afield and perhaps have repeated presentations like this across the region, because it really is very, very relevant to people involved in sport and an absolute must for athletes to know about. So thank you very much. And the question, as I said, is in a culture where we're not used to this sort of expediency, how does one instill that sort of culture?
Is it on? Yeah. I mean, just in response to that, though, I mean, I will say, like my second case that I did, it's either you want to be a sports lawyer or don't, right? I mean, that's fundamentally it. So if you can't get used to the fact that you have to stay up till 2 a.m. because 2 a.m. is really like 8 a.m. in certain parts of Europe, then don't do sports law. I mean, quite frankly, because sports law, it intrinsically sounds exciting. And if you are going up against lawyers from multiple jurisdictions, the first case I did, I had no idea what I was doing, but the guy I went against was England's best sports lawyer for that year. So I had to figure out, how do I beat England's best sports lawyer? So you bet I stayed up every night till 2 a.m. and I actually beat him. And that's what started my career in sports law. But you get over it because just like a surgeon, like you stay up all night, you have ridiculous 80-hour weeks. If you want to be a surgeon, that's what you go through. If you want to be a sports lawyer, then get used to it. If you really want to have every Sunday off for the rest of your life, maybe sports law isn't for you. But if you get a call from an athlete, the therapeutic use exemption, their appeal was denied, but they need to take their asthma inhaler, and the competition is tomorrow, and the entire Canadian team is in Germany, and they email you. You respond. Or if you don't want to respond, then get off people's radar and let someone like me take over who will respond, because I will respond.
Yes, thank you. You know what? I think we should introduce Dr. Crowe to our Chief Justice. I'm not using acting. Our Chief Justice, who has suggested that one of the ways in which to get rid of the backlog is to cut out, curtail cross-examination and all that sort of thing. I think Dr. Crowe needs to make an appointment to see Justice Sykes. Okay, the floor is open to questions for either Dean Mansing or Dr. Crowe. Yes.
Andrew? Andrew? I think you need the mic here.
I'm here contemplating the appeal policy that you have distributed, and I'm wondering about the approach. Is the approach sporting organizations putting in place? Do you coax sporting organizations to put this policy in place, or do you legislate it, or do you build it in existing legislation like an arbitration act or something? And where your headspace is at with it?
All right. Yeah, okay, so I mean, in relation to that, I mean, I think whenever athletes are made to sign athlete agreements or whatever agreements they have with their sporting bodies, as part of that agreement, this policy is part of the sporting body's other policies relating to like harassment or discrimination or how you behave, like travel policies, all of these other policies. And the way you force sporting bodies to do it is to say, is for the Olympic bodies or for the ministry to say, if you want funding from us or if you want us to ratify your nominations, as part of you adopting regulations concerning doping, you also have to adopt regulations concerning dispute resolution. If you want our funding, if you want our recognition, you have to also adopt this policy. Because these policies are very rarely, I haven't known them to be legislated in. They've all come, if you want, basically if you want our funding, you agree to this bunch of policies. And one of the policies in that basket is normally a policy about appeals.
Yes, Dr. Crowe, I looked at the grounds, and in particular the first ground. Forgive me, I have done my reading glasses, I'm struggling a little. And I noticed that you're proposing that the appeal should be circumscribed within procedural grounds.
Right.
I'm a little troubled by that because I can think of perhaps factual situations where an arbiter could make some ridiculous ruling, quite flying in the face of, say, a fact that has confronted them, and you are then dealing with a substantive issue. It's not so much that you failed to take account of something relevant or that you introduced something irrelevant. You just simply made a terrible boo-boo about how you interpreted facts or how you applied a rule.
Right.
It's getting into substantive areas, and I'm suggesting, therefore, that perhaps we might need to be looking at instances where the appellate process goes beyond that which is merely procedural.
Right, yeah, and they're characterized as procedural grounds because it's framed as being a body has made a decision, and so you want to know, well, on what basis can I appeal that decision? And they usually are limited to some sort of procedural error, because what happens in these disputes is the sporting body will get up for the appeal and say, our committee is composed of 5 ex-Olympians, Mr. Arbitrator, Mrs. Arbitrator. Who are you to overturn the decision of a body of 5 ex-Olympians? You don't even know the sport. You don't even know what's involved in wheelchair curling, which is a real thing. So, and then these policies have evolved to say, well, yeah, maybe in fact I'm not best placed to deal with selections when it comes to facts and so on. But as an arbitrator, I can spot when you made a procedural error in terms of the committee's deliberations. Because if we extend it beyond procedural errors, there is a real concern that you will have arbitrators picking teams, picking Olympic teams on their own then, like basically on the merits. And every sporting body in the world would resist that. But if you walk into an arbitration and said, yeah, well, you made a decision because you took into account irrelevant information. So the appeal that we won last month about reconsidering Canada's Olympic selections, it was because Canada's Olympic team was selected by comparing Canadian athletes to a list of international level athletes. 3 of those athletes were banned Russians. So we said that the procedural error that the Committee of Experts in Speed Skating, is Canada, it's the home of speed skating, the mistake they made is you are comparing clean Canadian athletes and including in the times banned, doped up Russian athletes, and it's unfair that the team, my client, should be left off the team because his average time did not meet the average time that included these 3 doped up athletes. You could leave the other athletes on, right? So those are grounds that an arbitrator could say, you know what, yeah, you should in fact not compare the 3 Russian athletes. Or you need to go back to the committee and justify why you still feel the need to include 3 Russian athletes. But to take it beyond that, you're running the risk of an arbitrator saying, you know what, yeah, you should be on the team. This is Canada's national team. Me, an arbitrator completely divorced from the sport. So that's why it's limited to procedural. Trust me, as an athlete side lawyer, I would love if I could open up everything and cross-examine the entire organization. Because every sporting organization is full of nepotism, anywhere in the world. And at least one person on the team is picked because they're the neighbor's daughter's, uncle's, grandson, something. That always happens. But the grounds are limited because there's a very real concern that arbitrators would exceed their authority and be picking national teams outright.
May I ask if we could, Dr. Crown, couldn't we borrow from administrative law? Because in administrative law, the court defers to the administrative tribunal, but the standard is that if no reasonable tribunal could have come to that decision, then the court would intervene, number one. And number two, it does not intervene to make the decision for the tribunal, but to send it back to ask them to look at it again. Couldn't that be a reasonable compromise?
Yeah, fair enough. And for the longest time in the sports jurisprudence, that is how the appeals were decided. They were decided by administrative law principles. And interestingly, the arbitrators who decided that were primarily from Quebec. So it was Justice Dicari, Dick Pound, those guys. And they applied, was the decision correct if it was just an interpretation of the law, or was it reasonable if it was a team selection decision? And it was almost impossible to say that, again, a committee of experts were unreasonable in excluding my guy off the team, right? But now, last year, there's now cases that say administrative law principles do not apply to sports tribunals. So there's a fantastic ruling which helps all of us immensely, because we used to have to overcome that hurdle. And if you see in one of the grounds of appeal, it's making a decision that was unreasonable, right? So the unreasonableness, that factor is in fact an admin law principle that comes into play. But the other factors that come into play are less administrative law based, because trust me, if you stuck to admin law, no athlete really won unless you found evidence of bias, which is extremely difficult to find, uncover evidence of bias in a compressed time frame. It's very difficult to uncover that.
Good evening. My name is Makilia Green. Dr. Crown, thank you so much for such an informative presentation. I am particularly interested and passionate about sports law. I had the privilege of being a part of the first cohort to have studied this course while I did my LLB here. In particular, we had to do a presentation to the class as a part of our grade, and I invited Johan Blake, Olympian, to be a part of my presentation, and it had to deal with IP and image rights, etc. And I do plan to take it further. Being a Norman Manley Law student, no. We have no courses. I see some of my colleagues here. We have no courses that really delve into this particular area, which I think represents a part of the future, right? So what advice do you have for a young law student who is passionate about sports law? What is the advised path that you would advise a law student to take? What is that path?
Yeah, all right. Well, I mean, the easy answer is take the LLM in sports law from September. Because, I mean, the LLM, I mean, it gives you the grounding that, quite frankly, like when you have to teach a subject, you learn a lot, you have to actually learn a lot more about it, as opposed to just appearing before CAS. I never knew why CAS was there until I had to teach it. I just knew it existed, and my appeal was to CAS. I didn't know it was founded in '84, and I didn't know the history behind that. So the LLM in sports law will in fact give you a good grounding in terms of sports law. And I do want to say that sports disproportionately, in a good sense, occupies much of Jamaican culture in particular. So Jamaica should in fact be the leader in sports law. And I mean, I'm selling the program, I point out my biases, but Jamaica should be the home of sports. It should be the leader in sport. We shouldn't have to go, like when Nesta Carter and so on, like when people have disputes, they shouldn't have to hire QCs from Spain and so on. There's enough people in the Caribbean who can handle those disputes. So there's that approach. And young lawyers, the best way to get in is contact a local sporting body, offer to read there as a lawyer, because make sure you're insured and so on, and to read, it's important, to read their bylaws, make sure the minutes are up to date, make sure they actually have annual meetings and don't just fudge meetings when it's time to get funding and so on, and also help them deal with disputes, either in terms of being a case manager for a dispute, or helping them mediate disputes or handle disputes, and quite frankly, do it for free, right? Especially early in your career, because then that body, as it goes through the years, then they will become your client. They will stick with you. They won't change lawyers. So that's the way to do, and there are enough amateur organizations that people can do that and help clean up the legal aspects of it, because all sports bodies need that help, and that's a way to get into the field and to start dealing with disputes and so on. Yeah, no problem.
Dr. Crowe, thank you so much for a very enlightening presentation. If nothing else, this afternoon you have debunked the myth that CAS is it. And so, you know, by being there at the table and working in these different environments, you're able to validate our capacity as being equal, at least equal to that of others. I was delighted to see that you ended where I begin. You ended with the word mediation. And I can say without fear of contradiction that there is a significant capacity in Jamaica and in the region to provide both mediation and arbitration. There are institutions that are privately run or run in collaboration with the government. And certainly in the case of Jamaica, where we have Part 74 of the Supreme Court Civil Rules, which actually allows for mandatory mediation in civil matters. And it had that same fight when it was being introduced, but it's become normal. Exactly. And I think there are a lot of resources, and I would like to suggest that perhaps the faculty might want to bring together a forum of institutions that are providing services in mediation and arbitration to look at what the best thing would be for us to develop in the region, using what we have already and bringing in whatever else we may need. Not in a competitive way, right, but in a collaborative way, right, that allows all of the skills and resources to benefit the many organizations that need those services. Yeah. So thank you. I've really been very enlightened by a lot of what you had to say.
No, thank you very much. And actually to that point though, there is, in sports dispute resolution, so arbitration is the default, but there is in fact something called MEDARB, which is mediation arbitration, which the same, because normally the mediator and arbitrator should be separate people, right? Because the mediator, you tell the mediator everything, you cuss, you carry on, but the arbitrator, you behave yourself, right? But med-arb, it's the same person. And I used to resist that process because I didn't want to taint the arbitrator with what the nasty stuff we said in mediation, with me being prim and proper in arbitration. But I've learned that there's some disputes where the organization is so buried in corruption and nepotism, get it all out in the mediation, and then if that arbitrator has the magic ability, like Data from Star Trek, to switch off that part of his or her brain and completely forget everything we've told them about bias and corruption and fraud and strictly deal with the arbitration, then God bless that person. But I have used it in cases like that when the organization has been so corrupt that I wanted, in fact, to have that process where we can beat them up in the mediation and then take it to arbitration. And quite frankly, the mediator too does a fantastic job of beating us up too. The mediator, even in these conference calls, has the ability to create separate rooms on the conference. And they put us in a room and they beat us up. But I tell my client, well, we're going to get beat up and here's how. So they know they're going to get beat up. But we let the mediator do their, it is theater in a sense. So the mediator beats us up, goes and beats them up, and then comes back. And quite frankly, there's a guy I request time and time again because he's so good. 7 out of 10 times he will get us to an agreement. And the problem is the mediator list tends to be a rotating list, so it's random. So I can't really request that person. But when I get that person, they're so good. Even though it's completely voluntary, and we could literally press a button and hang up. No liability, nothing. But nobody drops that call, most entrenched positions, and that person is so good. And then the relationship is maintained. That's the beauty of it. People, again, I can't say that enough, because athletes, as much as we as lawyers, we might be trained to be as rough to someone and then go and have a beer with our colleague later on, but athletes are not used to that. And when someone is slinging mud at them, saying they cheated in the competition, saying that their shorts were 2 inches lower so they didn't get as much wind drag, that happened in a case. And then now they're no longer friends. He's literally said, he blocked me from WhatsApp. I tried to contact him, blocked me from WhatsApp. Yeah, broke, done, end, right? So mediation and even med-arb, fantastic role in arbitration. And it is 100% left out. And I will shamelessly say that Justice Kokoram in Trinidad, he was tasked with, writing Trinidad and Tobago Cricket Board, redoing their governance policy, and he contacted me for how you deal with dispute resolution, and I sent him the chapter essentially on arbitration, and then I put in mediation, and he responded instantly and said, thank you for putting in mediation, because no one has even suggested mediation, and it is in fact a crucial piece of even for doping, it's a crucial piece of the puzzle because it maintains relationships.
Hi, Kwehu.
Where's there?
Okay, hi, evening everybody. Dr. Crown, I wanted to know your opinion on the Timmy Williams incident.
Okay, so I was counsel for Tima, so obviously we were right, but no, but that case is unfortunate because there was one limited appeal ground we had. There's something called the Tripartite Commission of the Olympics. So they deal with exceptional situations in the Olympics and allow athletes in. But the problem is the event that Thema was excluded from was the Olympic qualifier. So everyone said, look, she's a shoo-in. It's like, like you say in running a race, just pro forma, right? But if you don't actually do the race, then we can't say she would have been selected. So there's no way we could have won. And even if we went to the Tripartite Commission and we said, look, put her in the exceptional spot, the day before we filed the appeal, they awarded the spot to Belize. So we would have to ask them to ignore the fact she didn't Olympically qualify and disgorge an innocent party nothing. So it was an impossible matter to even raise. So we really had no recourse. And now Keith Scotland, he's the principal lawyer. So Keith, now they've sued in the High Court for damages and loss of opportunity and so on. And that is still ongoing right now. And even in the Commonwealth Games dispute, where I said we have an injunction, literally tomorrow, the Court of Appeal in Trinidad is hearing arguments to lift the injunction, even though the hearing on the merits is Monday, because the Trinidad and Tobago Table Tennis Association said if the injunction gets lifted Thursday, Friday they will send the names to the Trinidad and Tobago Olympic Committee that excludes our clients. So good luck with your case on the merits on Monday, because it'll be a moot point by then. Like, they literally confirmed that in writing. And this is what you're up against, right? So, and again, if it was a sports tribunal, the moment the selections were made, Trinidad and Tobago Olympic Committee rules there will be constituted within 2 weeks. 2 weeks, we would have heard the matter, had a decision, everybody moves on with their lives, as opposed to injunction. Court of Appeal, is it an urgent matter? Yes, we got that. They got, now Thursday, tomorrow, they're arguing the appeal. Finally, Monday is the merits, and the selections are due by the 6th. So I think Monday is the 5th, and then it's due by the 6th. So that's where we are, like beyond the 11th hour. And it's all in the High Court, and each side has 3 lawyers, and everyone wants their costs covered, and it's ridiculous, honestly. This is why we have sports dispute resolution.
Can I ask if you could expand on how you see mediation working in doping matters?
Doping? Okay.
All right. I'm sorry, it's off, a little bit off, but
no,
I'm particularly interested in it.
Yeah. So I mean, mediation and doping was one of, like, my initial gut reaction to mediation generally was because I saw it having no role in doping disputes, right? And like CAS, in fact, now has a mediation. They have rules regarding mediation, but it's not mandatory. And in every case I've done, no lawyer has invoked it. And when it comes to doping matters, it does help the situation because sometimes the facts are unclear. Exactly what it is we're arguing. Because we might say it's contaminated supplement. They might say, well, no, we're not even talking about a supplement. You're talking about something else. And you might diverge, right? I mean, even in the case, Riker Hilton's case, I mean, the case I did last year here in Jamaica, I mean, the allegation brought against him was a breach of a certain provision, right? Jadco says it's everything in the provision, 5 different things. And I say, no, I need to know, is it one of the 5 or all 5? Jadco says, no, it's all 5. And I said, no, I can't defend my client against all 5. I need to know the charge. And then we brought it to the panel, and then the panel had to decide whether it's the entire provision or a subsection of the provision. And the panel, by a majority, said it's just part of the provision. But if we went to mediation, we could have agreed on that. We could have agreed or not, right? But the point is, it would have saved, because that took an entire day, and nobody predicted. Because I just said at the opening, if my friend could just clarify, are we talking about evasion, or is it refusion, evasion? And he goes, it's everything. And then he goes, okay, Madam Chair. I'm like, no, sorry, Madam Chair. No, it can't be everything, because the provision contains 7 tortious wrongs and 5 criminal wrongs. So am I defending against 12 wrongs? And then the panel chair, Georgia Gibson Helen, she's fantastic at running the panel. So she said, well, you know, can you? So, but that's an example of how mediation would have helped solve that.
But it's not really mediation. What you're really talking about is disclosure. Proper disclosure. No.
Yeah.
The point I'm making is this.
Yeah.
A lot of times, and this is the problem I see, certainly for an adult, right? You cannot, because you're watched by WADA, you have to explain to WADA, even if you don't bring a matter forward, why you didn't bring a matter forward. And you're not allowed to come to a settlement or an agreement with the athlete outside of being able to explain to WADA why you have come to a particular decision.
So sorry. I just want to respond to that.
The thing about mediation, the idea of mediation is to settle your dispute in an amicable fashion.
Yeah.
But there are times where you are constrained by WADA.
Right.
If you say the athlete has had 3 missed tests, you must go forward.
Right.
And you have to explain why you don't go forward if you don't go forward.
Right. No, fair enough.
But say the reason we didn't go forward is because we have agreed to settle it in this way.
Right.
When the rules say this is what must happen.
Right. Okay, but in cases like that, so cases like that, I have been involved in settlements involving substantial assistance. So there's a rule under the code that if the athlete can provide substantial assistance to help uncover more doping, then whatever is the doping allegation against them, it can be reduced to a reprimand or eliminated entirely, depending on the nature of the substantial of assistance. So what we do is, in the mediation, it's me, the Canadian Center for Ethics in Sport, and WADA. Because WADA still has a supervisory role, because even if we agree, or JADCO agrees, WADA will still say, no, that assistance is not good enough. So I say, well then get WADA on the phone, wake up Montreal, I don't care, there's just a telephone call away. And then when we settle it, we sign off as athlete's lawyer, CCS signs off, and WADA signs off, because I don't want my athlete telling you everything, and then WADA saying, oh, it's not good enough, but thank you for giving us the names of 10 other doped up athletes.
So in the construct that you have, WADA would be a part of the mediation process?
Of this, correct,
okay.
Yeah, because of their supervisory role under the code, correct. Yeah.
I just want to point out, if I could, maybe that's when somebody's been convicted or has some sort of a charge. But where we have had mediation from a TUE point of view is that, and I'll give you, is from cricket, is that we've had instances, especially out of Afghanistan, where some record keeping has not been as pristine as it should be. Certain medications were used when perhaps others could have been used. We had members of our TUE panel adamant that no, this person should not be granted a TUE because you could have done X, Y, Z, or you could have done this test before you actually granted it. And we had to sit down and say, listen, that may be so elsewhere, but in Afghanistan at that time with that doctor, it was not possible. And when it came to head, we did actually have mediation there to sort it out before it went any further.
Any further questions? Yes.
I was taught to project. I thought I could make it. Thank you. Just to add on to what Dr. Mansing was saying, which ties back in, is while you have addressed it in a particular context about athletes, what we find is that there are a number of issues that end up in the public domain that harm athletes, that harm the sports, that harm administrators, and in the end sometimes harm the country being able to send appropriate representation to meets. And a lot of times it would be beneficial to use mediation in an organizational sense to enhance the way in which many of our sporting bodies function and have less problems coming to your shop. You don't want to do it on the mic.
You see, a big part of our problem, and you have alluded to it, is the lack of institutional capacity in our sporting organizations. That's really a large part of our problem. When you talk about, my words now, mom and pop operations, nepotism, one head cook and bottle washer, and it amazes me, I must tell you, where we are as a country in sports, I don't care, every single sporting organization should have an anti-doping expert in their organization, right? Every single sport should have the different disciplines should be adequately represented within the sporting organization. I can tell you, see Mrs. Blackwood here, simple things like seeing to it that the athletes have them insurance, right? where ministry provide insurance for an athlete, but the executive don't make sure the athlete have the insurance card. And look where we are now. We have Usain Bolt, we have netball team, we have world leaders all over. And our sporting organizations have not built out their institutional capacities. So you see this appeal thing, which you say get the donor bodies to insist that the sporting organizations put them in place. That's a good idea. That's a good idea, but I'm going to tell you, you're going to be, it's like dragging the horse, dragging the horse to water. And I am very fearful. I am very fearful. A lot of these organizations need to step up to the plate. That, as you say, they're probably not keeping proper minutes. They probably don't have proper accounting records. Barely know what is banned on the prohibited list on an annual basis. You know, it's really, it's a crisis.
Thank you very much, Dalton Myers. Dr. Crowe, I thought it was a very good presentation, certainly what I caught of it. Let me just ask though, in our Caribbean situation, certainly with a lot of matters, whatever it may be, whether it is anti-doping, otherwise, we always have challenges with time. Meaning that I know you always want to get everything through very quickly, get decisions, etc. But oftentimes that doesn't happen. And let's just use, I know Sir Chairman of JADCO is here, but just let's use that for instance. Whenever we have to discuss a matter, it will take time. Some people try to get injunctions, etc. And it can drag on for a long period. What confidence would we have now to certainly have a Caribbean appellate body for sport that anything will change there? And again, just using some examples that was just mentioned about our own sporting organizations. My general thought is that we need an overall with most of our sporting organizations, but that's for another time. I probably just want to stick with the and whether or not you think it is realistic.
Yeah, okay, I mean, to that point, I want to echo something that the Vice Chancellor actually said at the launch of the Faculty of Sport. He said the Faculty of Sport's launch was an attempt to professionalize how we treat athletes and sports in general. And I think just the same way as athletes training, athletes nutrition, that's coming along, the same way that we have to change the way that we treat the legal aspects, the governance aspects of the sport. And really it is, like in terms of West Indian lawyers, the beauty of it is you will be on the ground of it, so you will have the opportunity to change it, but it has to come with just a cultural change in how we view athletes as just not being some recreational thing where somebody running on a football field randomly, as opposed to it, like Jamaica per capita should be the leader in every aspect of sports, not just athletes, but governance, anti-doping education, everything, harassment policies, everything. And I think slowly the change will come when we realize that all aspects of sports should be professionalized. And to Dean Mansing's point, there will in fact be scope for a sports clinic that will use the infrastructure of the open campus and so on to provide services throughout the Caribbean to any athlete that will want it. And I will say that it's not something that will change overnight, but it's the same way that athletes, the Vice Chancellor says, when Usain visits his office, he doesn't even drink water. And that is a change in an athlete's mindset that comes with time and comes with education and comes with training. And the same thing is with these policies. They seem very foreign now, but to me, it's routine. Like when I get a call, I assume the arbitration will be in 5 days, right? Like it's routine. Like I have an arbitration Friday, 1:30 to 4, because I have squash after. I didn't tell them that. I didn't tell them that. But and it just comes, and it'll just come with time. It's not. What I'm proposing now, quite frankly, is radical for West Indian sports dispute resolution. But let it be radical, because I don't want another Thema Williams to happen again. Yeah. Yeah. Right. Yeah, I want this to be on the record.
Yeah, no. It's there. We passed it at board level.
Uh-huh.
And what we're saying is that no more than 28 days from the time the allegation to the conclusion of an appeal.
Fantastic.
All right?
That's good.
So, we have amended our rules to say it, ran it by water, they didn't say much about it,
Right.
and I'm expecting the rule to be gazetted shortly. So let us see what happens there.
That's good.
Let us see what happens.
Any other questions? I'll tell you that it is not that difficult. As someone who was involved in the Caribbean Court of Justice, for example, as registrar, I am telling you, and any of you who have an opportunity to visit or to become familiar with the Caribbean Court of Justice, and I have practiced in New York for 15 years and involved in court administration in New York, and I'm telling you that the Caribbean Court of Justice is first world because they have put in place all the rules, all the systems, all the institutional systems, and also to you hear Dr. Crowe speaking of picking up the phone, doing a Skype, that sort of thing. You have to get into the 21st century. You have to get into the 21st century. In the Caribbean Court of Justice, for example, there you would not find a photocopy machine because it's a paperless court. And you would say, how could that be in the Caribbean? And it is because once you have the will to do it and persons who have the leadership, it will happen and the culture will change. All it is a change of culture in the way in which we do things. So I am not pessimistic at all. I think that the institution, because one of the things we have been working on is to get some funding in terms of assisting organizations in terms of governance. Non-governmental organizations, sports organizations. We have been working on some grant funding from the USAID in terms of us here in the Faculty of Law going out and helping them with governance, which is a critical part of this kind of thing. So we all have to chip in, we all have to have a role, but one of the things that I also want to point out is that we are talking global now. We are not speaking about a practice that is just Duke Street to King Street. What we are talking about is the entire world. Then you could be called to do a sports arbitration case in Korea, in Japan. You're talking about the island of Jamaica is not your limit. So, and this is how we're approaching the LLM, because we are in negotiation with other institutions all over the world in order to collaborate to give the persons who do this program an even broader perspective in terms of sports management and sports administration and sports arbitration. Do we have any other questions?
Yes, I would like to. I'm Florette Blackwood, and I am the Director of Sports in the Ministry of Culture, Gender, Entertainment, and Sport. I have been sitting and listening. I am here to represent the minister, but I'm also here in my own right, and very excited about this, because apart from being a sport administrator, I have studied at the graduate level in the area of conflict analysis and management. And Mr. Williams is here and knows that we have had several heated discussions friendly but heated in terms of the introduction of dispute resolution system within our anti-doping sector. My view is that one of the challenges that we face is that the program, well, all of the members of our disciplinary panel and our appeals tribunal, they're all volunteers. So when we put timeline also, and when procedures should be completed and decisions, that we also have to look at that, because that could be a factor that influence when these cases are settled. But also, we have found over the years, and please don't throw me out of the room, that there has been an increasing number of lawyers. We have athletes with 5, 6 lawyers on their team. I'm exaggerating, but we have with several lawyers on their team, and the culture that I have observed is one of win, one lose. So the whole approach of litigation versus mediation and settlement, that is not usually seen as finding a way to give legal advice and sound advice to your client, but on both sides, that you must win and someone must lose. And that I have observed is a critical factor in even the time and how we manage the process. And many times I believe that the losers are usually the athletes in terms of the time it takes for the deliberation, and so decisions are not taken fast enough, so that if they are to be sanctioned, but there's time for them to serve the period and return to their sport. And in fact, most of the time, that's the challenge that I find, that at the end of the day, even if the athlete become triumphant, if that's the word you want, I don't know that they are ever triumphant once they are brought before a disciplinary panel, but the timeline is such that it impacts negatively on the athlete, and that I'm really hoping that we can find a way to move towards. We understand that there are some issues that are best settled in one way versus another, but we at least, I'm very happy that at least we are talking about it, because this was not even accepted in terms of having discussion on this matter. And so I'm very happy, and for sure, based on my training, my background, and my interest, that from my position, this is an area that I would love to encourage and certainly with support in moving forward in any policy decision. Thank you.
Yes, that is going to be very key, that we bring all the stakeholders in to be involved, because you don't want the lawyers to take over and import the inefficiencies into the system. That is one thing you really don't want. If there are no other questions, I would just like to thank Dr. Crowe, thank Dean Mansing for a really very enterprising presentation. And thank you all very much for coming. There are going to be several other seminars. In fact, I have one working on now, which I am also, as I told you, a New York lawyer, and I want to examine the ways in which a place like New York, where the society is so litigious, and yet they have no backlog whatsoever. Yet every felony case must be tried within 6 months from the date of their arrest. The prosecution must be ready. Or the case is dismissed. And so I want to look at that and to see how we can go forward. I look forward to seeing you all.